Hello and welcome to this community outreach meeting on February 17th for Greenfield Farms LLC. This is a community outreach meeting for a proposed Tier 11 outdoor marijuana cultivator to be located in Greenfield. The address for this proposed facility is 446 Country Club Road, Suite C in Greenfield, Massachusetts. So with that, I'm going to turn it over to Blake to cover some topics that we're legally required to cover at this meeting. After that, we'll move into a public comment and question section. So I ask that you hold your questions just until we get to the end. Thank you.
Thank you, Quinn. So yes, as Quinn said, this is a community outreach meeting. I know you all likely just heard me discuss this before. So this is the same set of topics we have to cover. This is for an entity known as Greenfield Farms LLC. That is a single member LLC, and the owner, Michael Salimo, is on the line as well to answer any questions that are sort of outside of my regulatory knowledge. So yeah, I'll just dive right in. This is a proposed Tier 11 outdoor cultivation for 46 Country Club Ventures Suite C in Greenfield, Massachusetts. The same Cannabis Control Commission regulations at 935 CMR 500.110 apply. They must have full HD camera coverage, basically of every part of the facility where there's plants. And these cameras will not be trained anywhere else but the property. We'll have a security fence of a construction material to be determined by the local permitting process. And the lighting, I saw there was a comment in the chat in the last meeting about light pollution. So yeah, the commission has allowed motion activated lights. So this is not going to be, any sort of spotlight situation. There's no need for, staff to be walking amongst the plants at night. And as I said, there's some sort of dangers to having lights on a plant during what should be black, in the night because of the photosensitive nature of the cannabis plant. So yeah, that's the first line of defense, the camera coverage. You have to have every employee background check, fingerprinted, and carrying a marijuana establishment agent card issued by the Cannabis Control Commission. They must be 21 or over, no ifs, ands, or buts. As I said, there's no, police officer who's 20 who's going to be allowed on the facility. Emergency notwithstanding, state law still trumps and says you must be 21 to access this facility, and you must have a valid business purpose or inspectional purpose. So, local board of health, fire department, police department, state's Cannabis Control Commission, or someone there who's a potential wholesale customer. The Cannabis Control Commission regulations require that there be a plan to prevent diversion to minors. Again, first line of defense there is you can't be on this property, which is private property, unless you are an employee, an inspector, police, fire, et cetera, and you cannot be under 21. So that's the first line. The second line is a contractual one that I recommend my clients include in their wholesale contracts, which says if the state's seed to sale tracking number that is tied to their product in this license were to end up in the hands of a minor, it's not just put the blinders on and say, oh, that's not our problem. You can know exactly to whom you sold that, and then you can find out how that ended up, to an extent in the hands of a minor, and that would be cause to terminate the contract. So that would jeopardize someone's license if their products ended up in the hands of any minors, and frankly, it would jeopardize the license of anyone who sold that product to a consumer. The state has a state law that requires there be a positive impact plan with capital letters. That plan is intended to try to undo some of the wrongs of the failed drug war. So what the state did is they identified through statistics 29 areas of disproportionate impact where people got arrested and convicted more harshly than people in other communities. So people of color and Caucasian people consume cannabis at identical rates. The ACLU actually ran the numbers a few years ago, and a person of color is 3.7 times more likely to have an interaction with the law, and then the consequences of that interaction for people of color tend to be much harsher. So what the state said is, if this industry is going to come up in Massachusetts, we need the folks who intend to participate in it. We need them to give back to try to, as I said, undo some of those harms. So yeah, Greenfield Farms has been intends to donate annually to the New England Veterans Alliance. That is, as the name implies, a veterans focused entity that provides education to people in one of those 29 areas of disproportionate impact. And a lot of what they teach has to do with cultivation. So it is legal for an adult to grow up to 6 plants at home, just for adult use purposes, or 12 if there are 2 adults. The rub with veterans is many of them have the need for federal benefits or to go to a Veterans Affairs hospital. The federal prohibition of cannabis means that they can't get a recommendation for that, despite the fact that cannabis has been shown to be beneficial to veterans. So that's one component, and the other component is intending to be a dialogue with Greenfield, a dialogue with neighbors. Where would charitable dollars do the most good on the ground, and where would volunteer hours do the most good? So yeah, some things that my clients have done would be a Thanksgiving turkey drive, a river cleanup, a park cleanup, some sort of active volunteerism to hopefully get folks to say, hey, these are good corporate citizens and good neighbors. The last required topic, and I'm just being mindful of the questions we have bottled up here, is information adequate to demonstrate that the location will not constitute a nuisance as defined by law. So as I said, there's no get out of jail free card, any license, any host community agreement, any local permit. None of those could be held up by Mr. Salimo and Greenfield Farms and say this entitles me to do whatever I want. No, that's not the case at all. So the Cannabis Control Commission regulations require a few things. A, you can't be able to see the plants from the public way without binoculars or a telescope, and you can't cause a nuisance in the form of odor, which I do think with outdoor cultivation that's really the prime culprit. But there are strategies both in terms of placement of the plants in light of the rest of the property. As well as some companion plantings, native plants that emit a smell that would, essentially, compete and mask with the smell of a cannabis plant. The way cannabis develops is it really doesn't start to smell until it's really pretty near maturity. So I'd say the window of potential smell would really be about 6 weeks, and it's not just, oh, we can stink up the joint no matter what. There would be a mechanism both under Cannabis Control Commission regulations as a function of the host community agreement with the city of Greenfield, as well as likely a special condition on a special permit that says, here's what happens if we do have an odor issue. And again, it's not just we don't get to say this is not our issue. It's something that we take very seriously, and Michael does have experience with outdoor cultivation, if memory serves, in the state of Michigan. So he has, direct experience with how to mitigate this sort of thing. So with that, I'll turn it back over to Quinn. And I know we've got a queue of questions that are piling up.
Yeah, thanks, Blake. I'm going to start with just some of the questions that we've gotten from the chat so that we can get to those, and then I'll call on some people to ask more questions. So first, how much square footage will be covered in buildings and how much will be covered in blacktop?
Blacktop, I don't think there's going to be a whole lot of paving. Michael, I don't know. I know we're still developing the engineering plans, but the same size building, is probably likely. So I would say, 5,000 would be on the sort of outer limits of what that building might look like, and that would be for drying, curing, and sort of finished product storage. And yeah, I don't know, Michael, if you know off the top of your head on any of the blacktop stuff.
Yeah, correct. We try to be least invasive to the property in its entirety. So if possible, we would like to actually use no blacktop. Most of our drying is going to be done in some new innovative, smaller pods, they call them, that will be put right on, 3/4 clean and railroad ties. We'll have everything painted and looking nicely to, mask it and be appropriate for the surrounding areas. Our goal here is to be, least invasive as possible, leave the earth as we found it, and, operate a really good, clean business that's sustainable for us and the community.
Thanks. Next up, when my kids come home, they love that they can see the stars and that there's little light pollution. Are there going to be lights on at this facility?
Yeah, there will be, as I said, likely motion activated security lights at night. There will be no spotlighting. And that would be, again, something that would be, attachable to a special permit as a special condition. And yeah, that's sort of a typical function of any zoning process. So yeah, light pollution is definitely on the radar. This is not like a high-tech greenhouse where you have artificial grow lights. So when the sun sets, that is signaling to the cannabis plant to start various biological processes. So if it's not dark at night, that affects the growth. So there's sort of an inherent disincentive for an outdoor cultivator to have anything more than security lighting, and there's going to be no cause, absent some sort of emergency response, for any lighting to be on overnight.
Yeah, absolutely. We're just as if not more sensitive to the light than anybody really.
And then a follow-up question on that one from the same individual is, can you address how it'll affect wildlife, as there's bear, deer, turkeys, coyotes, and other animals that travel through the area?
Yeah, I mean, it's like any agricultural use, although technically under the law it's not considered agriculture. But yeah, I mean, the primary effect will be the fencing around wherever the plants are. So I don't believe bears or coyotes or deer have any sort of affinity to cannabis. Part of the psychoactivity from the cannabis plant, botanists have theorized that it was used as an internal defense mechanism. Not unlike those, can't remember the name of the toad, but the toad that has the hallucinogenic mucus, right? A coyote tries to eat that once and learns its lesson. And I think there's some sort of parallels. So yeah, I have not heard, obviously out in sort of different climates, there's a lot more outdoor cultivation than in Massachusetts. I haven't heard anything from, California or Oregon or Washington of any, major impacts on wildlife, other than just having that natural barrier of a fence. But again, there's not really anything that would be super attractive to any of the native wildlife. Cannabis is, it's not part of their diet because it's not from here.
Yeah, and I can add to that with my experience out in Michigan. I'm very partial to the outdoors. I'm an outdoorsman myself, and we try to have little impact on that wildlife as possible. We have a pretty short season, a pretty short growing season, and I think Blank had mentioned earlier with some of the odors. We have to harvest our plants so quickly during that ripe time in order to get them to the proper facilities to care for them and process them and get them off the property. So a lot of times in the down season out in Michigan and things, it's a big hunting culture and it's a big outdoor and snowmobiling culture. So we allow a lot of the neighbors to use land. People have asked if they could have licenses to hunt on it. I don't know the laws exactly in Michigan, so Massachusetts on that, so I don't want to overspeak. But again, to be least invasive as possible, we really have a pretty short window of a grow season, especially in that climate.
Thanks. And then the last question from this person, then we'll move on to some of the folks who have their hands raised. What do the 3 suites mean? Can you explain this further, please?
Sure. So there'll be 3 distinct entities, 3 distinct licenses, 3 distinct fence lines, and 3 distinct, drying, curing, vault apparatus. They're going to be next to each other. But yeah, that is to comply with the state's regulations. And yeah, the designation of Suite A, Suite B, Suite C is just so mail goes to the correct entity. But it's, a common landlord and obviously the same piece of property. But yeah, it will be legally distinct, physically distinct. And that is the reason for the 3 suite numbers or letters in this case.
Thanks. Bob Wallner, you've had your hand raised for a while.
Thank you. One of the things I read about the Tier 11, which is what I believe you guys fall under, is that you may cultivate, obtain, manufacture, process, package, and brand marijuana and marijuana products. What is the extent that would be being done on the country club properties?
Sure. Just one correction, a cultivation license does not allow you to manufacture. That would be under a marijuana product manufacturing license. So yeah, what will happen here is the cultivation of the plant, the drying, the curing, then sending out a sample for testing. And then I'd say the primary customer here will be product manufacturers who will take the raw biomass and turn it into other things. So likely outdoor is typically turned into cannabis oil, which can be input to edibles, vaporizer cartridges, or some of the other forms of concentrate. But yeah, that is not a license type that this entity is applying for. So as I said, grow, dry, cure, test, and then sell it wholesale to likely someone with a manufacturing license.
Okay, one additional question for you, and something maybe you can't answer, but we'll need to look into is, you're in an area where much of the public utilities, such as public water and public sewer, have not been relocated out to in some areas out here. How is runoff and water usage from those of us who do have public water going to be impacted by this?
Sure. So the first line of defense of any sort of effluent runoff is that the state's Cannabis Control Commission regulations prohibit the use of pesticides. The reason pesticides are prohibited is the way EPA registers pesticides. It's not really based on its sort of chemical composition, other than to say this particular chemical. What they do is they have a list of plants or agricultural products you may put that pesticide on. So because of the federal prohibition, there's not one federal EPA list for pesticides that include the word cannabis. So because of that, the state said, okay, you can't do that. So yeah, I mean, there's also testing requirements, again, to even be eligible to sell it at wholesale, where they test for pesticides, mold, microbes, that sort of thing. So this is a really pretty clean process. My understanding is that outdoor grows, are sort of doing their best to minimize water usage. I don't know, Michael, if you have off the top of your head about the water usage, but my understanding is that they're going to be doing a well for the property.
Yep. Yeah, I could jump in. So yeah, we'll be doing a well for the property, and we use these small water emitters that go right into the root of the plant, so we can really control the feeding for it. And also to just touch, on the pesticides things, and for me in a simpler way, and what we've had to deal with out in Michigan, we're held under the strictest guidelines. So we've actually had experience, which they call drift, where our plants and everything that we do, we can't use anything, so they're so organic. But vegetation farmers, corn farmers, and lettuce farmers next to us, and soybean, are allowed to use pesticides that we all eat every day. And when they were spraying, they actually drifted over to our product. And some of our products actually failed testing because of neighboring lots of what they were using. So it just kind of goes to show how clean we really are, and how important it is for us to stay that way too.
And yeah, just one final point, just again, the no nuisance requirement would apply to runoff, right? So if they're, you'd lose your license if you use pesticides. If, any chemical is migrating from this property to anyone else's, that's a trail of breadcrumbs that's not that difficult for a hydrologist to figure out. So yeah, there's just no incentive to emit that kind of thing, because it could jeopardize the license and result in a lawsuit from a neighbor. So yeah, it's controlled delivery of the water, in a calculated manner to basically not overwater, because that would have a negative impact as well.
Thanks. Question from Veronica. She wants to know when the meeting will be for the public to come forward with concerns regarding this.
Yeah, so our next step, we need to have the finished drawings that would be exhibits to the special permit application and the site plan review. So what will happen is that will get mailed out as a function of those hearings. So we haven't applied yet. Our hope is to apply, I would say, in the next month or two, sort of based on the backlog of engineering drawings. And then that gets, anyone who's on this mailing list is certain to get a notification of that public hearing. And again, as I said, I was a former municipal attorney, so that's where I become useful again. I can help navigate those local permitting requirements. And absolutely, that's when, the powers that be to say, yes or no to a permit, where every single one of the concerns that everyone has raised, will get aired, and the municipality of Greenfield has the power to say, do this, not that, obviously within reason.
Thanks. Nancy and Fred. Nancy and Fred, are you there? Tamara C.
Hi, thank you. So I had a couple quick questions. So as far as I knew, I thought that that land had been put over into chapter 61A. Is that correct?
Yes. So for those who don't know, 61A is an agricultural preservatory statute. So what happens is when someone wants to take, it's called chapter land. When someone wants to take land out of chapter land, there's a statutorily prescribed mechanism where you basically go back to the municipality who, as a function of letting that property get a tax break for being chapter land, they get a right of first refusal to buy the property to preserve that. So yes, I'm keenly aware of that process. Honestly, I don't recall if that right of first refusal has come and gone, but what will happen is if they don't exercise the right of first refusal, the landowner will have to pay the taxes as if it weren't chapter land, basically from however long ago that designation came, because it would no longer be chapter land.
Right.
And yeah, there's a legal quirk. Cannabis is not legally defined as agriculture. Had it been, this land would have, been able to stay in the chapter land process. And to get very nerdy on you, the reason that's not legally cannabis is because MGL chapter 40A section 5 says that on any property that's 5 acres or larger, it's illegal for a town to zone out agriculture. So what the legislature did is they said cannabis plants growing outside is not agriculture. And that was, frankly, to your benefit as neighbors. If that were the case, we wouldn't have this meeting because the town wouldn't be able to say anything. So yeah, it's really to the benefit of neighbors that it's legally not agriculture.
Okay, so isn't the purpose of it is for chapter 61 is to help keep the land undeveloped? So as far as I know,
I mean, there's a couple of flavors of chapter land. So it's for, agriculture,
Right,
silviculture,
61A.
which is like tree farming.
Right.
But yeah, people come in and out of chapter land all the time.
Right.
It only remains permanent if the municipality elects to buy the property. It's definitely, a carrot to get people to keep it that way forever, but it's not permanent. And as I said, there's a statutory mechanism to take land out of the chapter 61A.
Right, but I thought that there was a certain amount, like, I didn't think you were allowed to build on it there was some laws into that, no?
Yeah, so once it's out of chapter land,
Right.
it ceases to have those restrictions. Correct.
Okay, I guess that's my question. I don't know how to get it across, I guess. All right, so the other thing is for the total 3 lots that you're proposing, do you know how much acreage you would be taking?
Yeah,
Like
so
in
the tier
the fence
11,
included?
sorry, say that last part again.
With the fence and the buildings and whatever included, how much for acreage would it be?
So the place where plants are per entity per license is limited to 100,000 square feet, which is 2 acres and change. There's going to be a little bit of what's legally known as curtilage around each fence, just sort of a little bit of a buffer. So it's not going to be fence to fence directly. So I would guess this will probably cover a total of maybe, let's see, 100,000 acres is 2 and a little bit. So yeah, I would say grand total, you're looking at maybe just under 7 acres.
Okay, all right, and then money, so the state had paid money, I'm not exactly sure, sorry, this is a question from my father.
Sure.
Sorry. I don't know what you mean by this, money.
20 years ago, the money was given from the state to them.
You have to get okay. Can you come here? Sorry, just one moment.
No worries.
Thank
Some
you.
years ago, when the monies were given from the state to the landowner to put that into safe haven for the land would not ever be touched for residential building, whatever. But that was a substantial amount of money, taxpayer money. Now you're saying when they can take it back out. I thought that was already tried and didn't happen in the state of Massachusetts. That they removed it, or they tried to remove it and pay back that monies, and they didn't. And I understood it wasn't allowed. How is this?
So
different?
61A, it's
Was it 61A though?
I'm not familiar with what you might be referring to, but yeah, 61A has a clawback provision where they tax you less when you're chapter land. When you come out of being chapter land, you have to pay back the taxes as if it had never been chapter land.
Yeah,
So
but
it's
we're not talking about taxes. We're talking
Yeah,
about
I do not know what you're
the money that was given to the landowner at the time to put that in a preserved land, so that could never be built on. I'm talking about that. I don't mean the taxes on it. I know the taxes are reduced
Okay.
in 61A. Everybody knows that. Everyone knows it. But not that. The monies that the state actually paid the landowners to not ever put it into a whether it be a subdivision or whatever, you know.
I honestly do not know the answer to that question. I have not personally seen the state pay anyone to put land into chapter. The real carrot is the avoidance of the maximum tax. So yeah, my clients aren't the landowner, so I truly don't know the answer to that. I apologize.
I think he's
Yeah, well-
talking about the APR program. It's under agricultural preservation restriction, just to help tie this
Yeah,
together.
that's 61A. So he's saying it's not.
No,
it's
it's
totally
just-
different. APR is a permanent preservation program the state paid for, and
Right.
his property's under APR, which is a permanent conservation restriction. There's a question on this in the chat also.
Okay. So I don't know the answer to that off the top of my head. But yeah, we will have to comply with every, state rule, state law, state everything in order to get to the finish line here. So that's something that I'll have to look into and get back to you on. I don't know the answer to that.
Well, I understand, and I have it right here from the current one, and then the agricultural covenant land program, that they cannot. I think, and like I said, I believe it was tried in court, and the reps in Mass will be back to me, I'm sure, with about the information on, and that it couldn't be brought out of that. It was monies paid to the landowners back in the 70s and 80s. For this exact reason.
So yeah,
it couldn't be
basically
changed, and it couldn't be
the
pulled
chain of
back out of
title. Sorry, go ahead.
And it couldn't be pulled back out of that. So how does this, and you couldn't build on, the only one that could build on that properties was the homeowner or the property owner of that farm or whoever, but, or their children or whatever, but they couldn't, you couldn't put another type of building up. It was strictly what I just spoke
Okay.
about.
Well, I will, I'll include my email in the chat and I'll get an answer to you. I just don't know the answer off the top of my head. The lease for the property, basically says the landowner has the right to rent it to the tenants here. So if they don't have that legal right, then that's sort of a different issue. I just am not familiar enough to give you an answer right now, so I don't want to pretend like I know when I don't. So,
Yeah.
Hey, Blake, if I could say something too, our intent too, is, I know we're not considered agricultural, but really, besides the fact that we're required that fencing and more blocking than a soybean or corn grower, we're gonna
Doesn't
have,
matter. Well, right.
this is not going to be industrial looking. It's going to be, a similar barn to as if somebody else was producing and growing harvest or drying corn or whatever it may be too.
Well,
Like we're not.
What will be the hours of operation if that's the case?
that
No,
would be
that's not
set
what I'm
by
referring to.
Yeah, that would be set by the special permit granting authority. But yeah, I mean, daylight hours is what I would say. There's no real incentive to work overnight. But yeah, that would be a local permitting, floor and a ceiling on that.
Right.
And I
A
apologize.
6
We are up against the next meeting. So if I can just ask everyone to jump, and I know this is clunky in retrospect, I should have done this for 3 different nights, but I will get through the regulatorily required topics as quickly as possible on this next one, because I understand that folks do have a lot of questions.
Then do we get back in line in the same place we put our hands up, or do we have to listen to the whole
Yeah.
thing?
I'm gonna ask Quinn to record it right now. Yep. Who's asking what? Yep.
Yeah, I have
Greenfield
a-
resident. Yeah.
4 of you still, sorry. All right,
So if you
the
can
link
jot that
is in
down,
the
Quinn.
chat, so you can click that and move to the next meeting once this closes.
See you guys in just a second.